ready to go.
Good morning, everyone. The COGCC hearing on this morning, Thursday, February 27th, will come to order at 9:05. Ms. Larson, will you please conduct the roll call?
Yes, Mr. Chair. Commissioner Boygan.
Here.
Commissioner Eaton.
Here.
Chair Gibbs.
Here.
Commissioner Hahn.
Here.
Commissioner Hopkins.
Here.
Commissioner Jolan. Commissioner Mesner.
Here.
Commissioner Overturf.
Here.
Commissioner Putnam. Mr. Chair, you have 7 out of 9 commissioners present.
Great. Thank you so much. This morning, the first item we have is docket number 190100177, operators Crestone Peak Resources Operating LLC. And Ms. Larson, you want to take over from here?
Yes, I'd be happy to. So each party has 15 minutes for their presentation, and we will begin with Crestone.
And for the record, please introduce yourself and let us know who you represent. And before you start, Commissioner Hopkins.
Thank you, Mr. Chairman. I'd like to make a short statement, and this is for the benefit of the commissioners. As I think you all know, I was a member of the Broomfield Oil and Gas Task Force in 2017. And to give you a little bit more background, we were appointed by the City Council back in early 2017 with the charge to develop oil and gas regulations in response and update our regulations as part of the long-range plan in response to, at that time, extraction proposal from multi-well, multi-pads. And that's what we did, spent most of 2017 doing that. At no time, neither Crestone Peak nor the Global Pad were considered or discussed as part of our work on the task force. Let's go fast forward to my time as commissioner. I met with representatives of Broomfield city staff a couple of times, and our discussions have been focused on the upcoming rulemakings that we have, and at no time did we talk about the Crestone Peak nor the Godel Pad. So, in summary, I don't feel like I have a conflict and do not intend to recuse myself today, but I wanted to inform the commissioners about the background, my relationships with Broomfield and what I've been doing, and allow you all to have an opportunity to raise any concerns if you have so with my position on recusal.
Thank you
very much.
Yeah, thank you, Commissioner Hopkins. Are there any questions for Commissioner Hopkins? No? Thanks for bringing that to our attention. We appreciate it. Okay, the floor is yours whenever you're ready, and I believe you get...
15 minutes.
Yep.
Great. Thank you very much. Good morning, Chairman Gibbs, commissioners, council, and members of the public. My name is Jamie Jose of Jose Energy Law, and I'm here today representing Crestone Peak Resources Operating LLC on this exception to the hearing officer's December 2nd, 2019 order. Ms. Larson, I would like to reserve 4 minutes for rebuttal. Thank you. There are 3 reasons why the commission should overrule the hearing officer's order. The first is that the order is not in compliance with the Colorado Administrative Procedures Act, Colorado Supreme Court case law, or the commission's own rules. The second reason is that Crestone's approved Godel permits have been suspended for over 15 months. And the third reason is that the merits hearing on the approved Godel permits has no effect on Crestone's requirement to obtain a local permit prior to drilling, but the local disposition is not required prior to a hearing on the merits of the approved permits. As we proceed, there are a few items that we would like you to consider as you evaluate Crestone's position today. The first is that the only reason we are here is because of the commission's approval of the Godel permits in December 2018. Broomfield challenged approved permits. A pending, unapproved permit would not have led us to this hearing today. No matter how Broomfield wants to classify its position, its right to object was based solely on the commission's approval of the Godel permits under Rule 305E2. There should be an immediate acknowledgement that the Godel approved but temporarily suspended permits are not the same as typical pending permits held for further staff review after the adoption of Senate Bill 181. The Oil and Gas Conservation Act does still require a timely and efficient procedure for the review of APDs. This did not change with the adoption of 181. 15 months is neither timely nor efficient for one simple location in Broomfield. And then finally, Rule 305E2 provides for an expedited hearing that has not occurred. This is an all-directions look at Creststone's one and only location ever in Broomfield, so you can put the location of this exception request into context. This is not in an urban area. This is not in a highly residential zone. This is not by a high occupancy building unit, school, or hospital. Before we dive into the law and rules supporting Creststone's position, it's clear that the order staying proceedings of the hearing officer is an initial decision on the matter by expressly providing that the hearing officer himself is making his individual decision to halt all actions on the approved GOLDL permits until there's a local government disposition. This is not an interim decision under Rule 532, and this is not a recommended order on the merits as contemplated by Rule 532. In the order, there is no reference to Rule 532, there's no reference to the APA, and there is certainly no reference to the fact that Creststone is entitled to expedited hearing under the Oil and Gas Conservation Act as well as Commission rules. The hearing officer's initial decision is expressly governed by the APA, which provides for the timing of the designation of record and the filing of an exception to the hearing officer's order, both of which Creststone complied with. Further, if Creststone had not filed the exception, then its right to judicial review would have been waived under the express terms of the APA. There's no flexibility in this. This is the law, and that law applies to these proceedings. Broomfield has argued that Creststone had no right to file an exception. The APA disagrees. Not only did Creststone have a right, but it had an obligation to file that exception, to do so, or to file that exception in order to have any further judicial review on this matter. Additionally, the APA, Section 244-104.52A, fully supports Creststone's position that the merits hearing on the approved GOLDL permits can proceed without a disposition by Broomfield on Creststone's February 2018 use by special review filing with Broomfield. The rules and written statements of agency interpretation that are in effect on the date the person applied for the permit, here in June 2018, apply to the permitting process. This is verbatim language from the Colorado Administrative Procedures Act. In June 2019, there were no rules that a local government disposition must occur prior to the approval of a permit. In fact, the facts of this situation actually take us one step further. We have an approved set of permits, not just those applied for under the APA. Further, the APA mandates that the agency must process the permit under the rules in effect on the date the application was made unless the agency takes proactive steps to address its comments to those permits. Here, the Commission has not taken those steps as allowed by the APA to otherwise prevent the GOLDL permits from proceeding to the merits hearing. The two sections of 244-104.52, Romanet I and Romanet II, were not utilized by the Commission and cannot now be utilized by the Commission against Creststone while attempting to preserve its approved GOLDL permits. Even if the Commission did attempt to utilize 244-104.52A, Section 104.53 applies anyway. This is a separate subsection of the APA that states that a person seeking the permit can choose what law applies for pending permits. To take this a step further, again, here we have approved permits governed by the law in place prior to April 16th, 2019, which was the date 181 became effective. This section of the APA allows Creststone to choose to utilize the Rule 305E2 for a merits hearing on the approved GOLDL permits. The hearing officer has failed to apply the governing provisions of the APA to its initial decision, and the order should be overruled. Colorado case law also supports Creststone's position in that Article 2, Section 11 of the Colorado Constitution prevents retroactivity of new regulations to pending permits or here approved permits. The Denver Buick case, which was cited favorably in Sauer v. County Commissioners of Laramie County, and even in the Denver Buick dissenting opinion, stands for the proposition that a person who applied for the permits, and again, in our case, intensified by approved permits, under prior rules and law, and before the adoption of a new law, should receive those permits pursuant to the former law. Denver, Buick, and Sauer remain good law on these points today and should be considered by this commission when reviewing Crestone's position. The hearing officer failed to apply this precedential Colorado law to its initial decision, and the order should be overruled. The current Rule 305E2 fully supports Crestone's position that it's entitled to an expedited hearing on the GOTL permits. Rule 305E2 ties only to approved permits. This is called suspension of approval. You don't get there any other way unless you have approved permits. While the approval may be suspended, this does not reclassify that permit as pending in the traditional sense. And when I say pending in the traditional sense, I mean a permit that has not passed completeness, that has not been out for public comment, and has not been through the technical review process of the staff. In this situation, the GOTL permits did all of that from June 2018 to December 2018. The suspension is only until the expedited adjudicatory hearing can occur, nothing more, nothing less under that rule. The hearing officer failed to apply the commission's own rule, and therefore its order should be overruled. My apologies. The commission has complete authority to overturn the hearing officer's order if the ultimate determination is based on an incorrect legal conclusion. As already discussed, the December 2019 order is based on several incorrect legal conclusions because it did not apply the APA, it did not apply longstanding Colorado case law, and it did not apply the commission's own rules. To bring us back to the second reason that the order must be overruled, this is because there is nothing about this case that lends itself to an expedited process or a timely or efficient permit review process as required by the rules and the Act. As you can see through this chronology on this slide, Crestone initiated the state permitting process in June of 2018, while it also initiated the local government permitting process in February of 2018. And here we are today, February 27th, 2020. Without going through the entirety of the chronological history on this slide, I will parse this down to one thing. Broomfield has claimed Crestone continued the matters and therefore it should not have a merits hearing. This could not be farther from the truth. Crestone was forced into continuances in January of 2019 when Broomfield failed to publish the notice for the expedited hearing. In April 2019, because the hearing officer did not respond to Crestone's inquiries about the hearing date. In May of 2019, because the hearing officer failed to inform the parties of the hearing until 3 business days before, and Broomfield stated they could not be ready for that hearing. And then again in June, July, August, September, and October of 2019, when Crestone had reached out numerous times inquiring about a hearing date and received 0 response from the hearing officer. Crestone has done nothing but try to get this merits hearing in front of you. And it was only on December 2nd, 2019, when this surprise order staying proceedings was dropped on the parties that we heard anything on this matter over the course of 6+ months. Therefore, the merit hearing on the approved GOTL permit should proceed in compliance with the rules as well as the Act. And then finally, back to the third point mentioned in my opening, the Broomfield USR permit is not required for the merits hearing on the approved GOTL permits. Crestone fully understands that it must have the Broomfield USR before it drills and has been trying to get one since February 2018. But this is not required and was not required under the law and rules in place in June 2018 when the permits were filed, as well as December 2018 when the GOTL permits were approved.
Ms. Jost, you've used 11 minutes.
I'm sorry?
You've used 11 minutes. If you want 4 minutes.
Use one more and finish up. Thank you, Ms. Larson. Broomfield makes it sound like a 305E2 hearing is going to be the end of the world, and in reality, this is going to be a benefit. The merits hearing allows the Commission, Broomfield, as well as Crestone to potentially add additional BMPs, conditions of approval, or mitigation measures onto those approved permits if the merits support those additions. One of Creststone's main frustrations with this perpetual delay is that they cannot get in front of this commission, and they cannot get in front of Broomfield to discuss new technologies and BMPs that could otherwise be employed voluntarily on this site. A hearing on the merits on those approved permits could allow this information to be reviewed and potentially utilized. So in closing, Creststone understands this is a case of first impression for you right now. We also understand and fully believe, though, that this commission has an incredibly high level of expertise in applying the appropriate law in a given situation. The decision to allow the required merits hearing on the approved permits is not going to result in an unprecedented number of hearings on this type of situation, nor will it result in a precedent for other pending permits, because this is likely a one-off factual situation with approved permits that unfortunately got lost in the madness of 181. Creststone is respectfully requesting that you overturn the commission's hearing order based upon his incorrect legal conclusions, and that you schedule the merits hearing at a future commission hearing. Thank you very much for your consideration of this unique situation that Creststone has been enduring for over a year.
Thank you. Phil Barber, Special Counsel for the City and County of Broomfield here, joined by Sean Sullivan and Pat Gilbert from the City Attorney's Office. I'm just going to talk. I'm not going to show a bunch of slides to you. So let me make the presentation by starting with a little bit more context than Ms. Jose gave you. The context is that in 2018, Broomfield began to study amending its rules and regulations for oil and gas development. In December of 2000, actually those discussions started all the way back in 2017, and they continued through 2018. When the Forms 2 and 2A were approved in December of 2018, Broomfield had not completed its regulation review and amendment, and the approval of the permits was under Rule 305, which gave Broomfield a right under the rules to ask for a suspension to apply for a suspension of those permits, which it did. The permits were suspended per the Rule 305E, and a hearing was set in January. It was continued. The hearing was then reset for March, and Council and Crestone Peak and Broomfield both agreed to continue that hearing. The hearing was then reset for May of 2019, and the hearing was again reset by consent of all the parties. At that point, Senate Bill 181 had come into effect, so we had two continuances that the parties agreed to before Senate Bill 181 came into effect. So I take issue with the idea that somehow Crestone has been forced into continuances. The record that we've presented to the Commission shows that they actually agreed to two of those. And then Hearing Officer Rouse, and then the hearings, as you all are aware, became subject to 19181. At that point, so we're now in April of 2019, two continuances have been agreed to by Crestone. Under 19181, the city assumed the right to do a site designation or review. It also continued under the objective criteria that the Commission issued to object to the permits in the Godel pad. The objective criteria that is now in place and that guides the Commission on whether to grant or deny permits in this interim stage while you all are making your rules gives Broomfield the right to oppose the Godel pad for four reasons. First of all, the Godel pad is within 1,500 feet of the jurisdiction boundaries of Broomfield. Second, Broomfield has assumed jurisdiction over the siting of the Godel pad. Third, there is a moratorium that has now been enacted by Broomfield, which Crestone recognizes effectively prevents them from drilling because they came to a Broomfield City Council meeting and asked for an exception to the moratorium, which was denied. Next, Broomfield is also in the process of amending its regulations. So there are a lot of moving pieces here. And the commission has a hearing officer who has had all of this evidence in front of him. We've actually had 2 pre-hearing conferences before Senate Bill 19181 was enacted. So the hearing officer clearly understands what this case is about, understands what law applies, and understands the limits of his authority and the commission's authority. So we look at, well, first of all, what this discussion is about today is the order to stay, not the merits of whether Crestone should be given drilling permits, not the merits of whether there are health, safety, and welfare best management practices that should be added to those permits, although Broomfield did ask for additional best management practices. What this is about right now is whether the hearing officer's order for stay is even subject to review by this commission. Under Rule 532, interim decisions are not subject to exceptions. And the reason we're here today is because Crestone Peak has filed exceptions. 532A provides, subpart 1, interim decisions are issued after an application is set for hearing, but are not recommended orders that may become a final decision of the commission. So we are not talking today about a recommended order from hearing officer Rouse. We are talking about an initial decision. 532A2 clearly states, interim decisions shall not be subject to exceptions. Let me repeat that. Interim decisions shall not be subject to exceptions. Our position is the commission as a whole does not have jurisdiction under its own rules to consider these exceptions. The rules say that the exceptions, that hearing officer Rouse's order for stay is not subject to exceptions. There's no ifs, ands, or buts. Crestone tries to get around the fact that interim decisions are not subject to exceptions by calling hearing officer Rouse's decision a, quote, initial decision, which is subject to review under the APA. That's section 24.4.105. Hearing officer Rouse's stay order cannot be an initial decision because an initial decision contemplates a decision on the merits. There has been no hearing on the merits before hearing officer Rouse. You won't hear any dispute about that. So under the APA, there is no initial decision that can be appealed to the commission for review. So calling it an initial decision is really a ruse to shoehorn this case into the APA, and it is not an initial decision. Ms. Jost mentioned a statute, another statute under the APA, section 104.5 of 24-4-104, that gives some flexibility to parties in Crestone's position, where they want to appeal a decision, to opt to appeal under the old orders, old rules. The problem with that is we don't even get to that point, because the only way that we get to that point is if the exceptions that Crestone filed give this commission authority to do anything, which they don't. But let's sort of put aside that. So does section 104.5 give Crestone the flexibility to proceed under prior commission rules or prior law? No, it doesn't. Why not? Because section 104.5, Romanet 1 and Romanet 2, specifically contemplate that that flexibility does not exist where there has been a material change in the law, or where the rules that are in effect after that change are necessary to protect public health, safety, and welfare. If anything describes Senate Bill 19181, it's that. It's been a material change in the law, and the law specifically is intended to protect public health, safety, and welfare. There has been some suggestion by Crestone that its due process rights have been violated. And we interpret that to mean that Crestone believes it had the right to go and drill wells, and those have been denied. That cannot be true. Crestone has never had the right to drill on the Gottle pad. That's just the fact. There was an approval by Director Lepore of permits back in 2018. We took the appropriate procedure to appeal that approval. Crestone has never had the right to go out and drill wells, so it has never had any rights that were violated under the Due Process Clause. All of its rights were contingent upon the rules of this commission and the laws of the state of Colorado. Crestone continues to say it has vested rights. It does not have vested rights. It has permits that have been suspended. Those suspended permits are subject to an expedited hearing process, but as I said, the parties both agreed to continue the initial hearings that had been scheduled, and now we're under 19-181. And under 19-181, we disagree with Crestone Peak. We believe that Broomfield's right to weigh in on the siting of the wells, Broomfield's right to issue a use by special review permit, Broomfield's right to object to the health, safety, and welfare components of the permits that have been approved but are suspended are all matters which, under the operator guidance, give Broomfield the right to appear in front of the commission today and ask that the permits remain suspended until the matters that are contemplated in the operator guidance have run their course, which they have not. So I, on behalf of Broomfield, request that, first of all, the commission recognize that it does not have jurisdiction over the exceptions that Crestone has filed, that the commission recognize that there has been no initial decision, because initial decisions are after testimony, evidence, and hearing. There has been no testimony, evidence, and hearing that would create an initial decision by hearing officer Rouse. So the APA, frankly, just doesn't apply to this situation. What does apply? There's a case called Chase versus COGCC. And in the Chase case, the Court of Appeals said that determinations by the commission, which we interpret to mean including staff, including hearing officer Rouse, are subject to a very, very limited review. That's assuming they even get before you on their exceptions, which we don't think they do. But let's assume they do. Under the APA standard, this commission would overrule hearing officer Rouse's decision. And remember, he is the person who has handled this case, has had several pre-hearing conferences, knows what the case is about. You would overrule him only if you felt he had abused his discretion in issuing a stay order. And based upon the facts before you all, how can it be an abuse of discretion with a new law, with a moratorium, with no health, safety, and welfare, or inadequate health, safety, and welfare conditions applied to these permits, with the fact that both parties asked for continuances? How can it be an abuse of his discretion to order a stay until the dust is settled on 181, until the moratorium is removed, until there has been a use by special review permit issued by Broomfield? How can that be an abuse of discretion? We suggest it is not, cannot be. So we would ask you to, first of all, dismiss the exceptions because you have no jurisdiction to hear them. But if you did, I think you would examine hearing officer Rouse's order under an abuse of discretion standard. Clearly, that does not exist. Thank you.
Thank you for your testimony. I believe, Ms. Jost, you have a few minutes.
Yes, 2 minutes and 11 seconds. And Mr. Barber, you have 3 minutes and 5 seconds left.
Great. Thank you again, commissioners. I think there's one thing that Broomfield and Crestone can agree on, and we're going to mark this on the record, is that the only thing at issue before you is the hearing officer's order. First and foremost, under the APA and the case law, the objective criteria that's been mentioned several times by Mr. Barber cannot apply here. It cannot apply per se to these permits. These permits were approved in December of 2018 under the APA and case law we already discussed. That would violate the APA and the written statements of agency interpretation on the law. The other aspect is, as provided in Rule 532, Mr. Barber states that this is an interim decision. It cannot be an interim decision. The plain language of your rules states that interim decisions are issued after an application is set for hearing. This has not been set for hearing. This cannot be applied. This recommended order has not happened under Rule 532B. There have been no hearing on the merits. The pre-hearing conferences Mr. Barber alluded to happened in January 2019 prior to the first commission hearing. Additionally, the default is the APA. The APA governs everything this agency does, including your hearing officers. Under 24.5.105.14a, that allows for an exception to a hearing officer's initial decision. It does not limit that decision to the merits of the decision. Counter to all of this is that if you buy Broomfield's argument, basically you're saying Crestone has no rights to arguing its matter on an exception, appeal, or otherwise. We are stuck. We are stuck even though you have Rule 305A2 that gives us a right to an expedited hearing on these approved permits. We never said we had a vested right to drill. We have a right to an expedited hearing under Rule 305E2. To the context of the allowances under the APA for 24.4.104.521 and 2, if the commission was going to exercise its authority under the APA, it had to do so in writing. It had to provide written notice stating the reason the application was incomplete pursuant to the APA. It had to have determined in writing that the approved global permits were being treated as pending. It has not. And it also had to...
Your time has expired.
Okay, may I finish for 10 seconds? Okay, thank you very much, Chairman. And then it would have had to allow Crestone a reasonable opportunity to comply with the new rules or new requirements. Here, none of that has happened. And so again, we just would respectfully request that we receive a hearing on the merits of the approved permits and proceed forward on this matter. Thank you very much for your time this morning.
Thank you. I'll use the rest of my time mostly to read a paragraph from Hearing Officer Rouse's order. And again, you're reviewing this under an abuse of discretion standard. This is paragraph 8. When the local government, meaning Broomfield, where the wells are located, objects and requests a hearing, as is the case here, there is no final agency action on the permits. Citing order number 1R-106, Statement of Basis and Purpose for Rule 305, page 28. Parens, quote, the director's approval of a Form 2 or 2A will be suspended if a party withstanding under Rule 503 requests a hearing within 10 days after the director's decision is issued. That happened here. Hearing Officer Rouse continued to justify the order for stay by writing, moreover, the statement of basis and purpose for Rule 305 provides that permits will issue, quote, only as proposed by the director, and the director's decision is deemed a final decision of the commission, if no party withstanding under Rule 503B7 requests a hearing. Accordingly, the well permits are not final agency action and are still pending before the commission. Citing SB, and then he says, SB 19-181's amendments, including Section 34-60-106, 1F1A, therefore apply to the well permits, which give Broomfield the right to make the initial decision on site, location, and health, safety, and welfare requirements. So this matter is not ripe under the APA, and it is not even allowable under the Commission's rules. Thank you.
Thank you. I believe both time has expired. Ms. Larson?
Mr. Barber does have 1 minute and 12 seconds left, if so needed.
It's harder to write a short speech than a long one, so I'll stick with the short speech.
Yeah. Okay, great. Thank you for those presentations. Commissioners, comments, questions? Commissioner Boygan.
Thank you, Mr. Chair. Mr. Barber, you
talked about the two continuances, and you use those as a justification for the absence of an expedited hearing, but there were another 6 months or so after those two continuances, right, where Crestone was trying to get someone's attention, couldn't get a response from the hearing officer, couldn't get a hearing set. Is there a reason that you're aware of that nothing happened during that 6-month period?
I think you can use that microphone. Yep, you can use that mic.
Commissioner Boygan, during that 6-month period, I guess I beg to differ that there were repeated efforts by Crestone to have this matter heard. If you recall, one of the hearings was in May of 2018 that was continued. 19, I'm sorry, and in 2018. And during that time,
19.
2019, it was after Senate Bill 19181.
Right.
So I think the answer to your question is that Hearing Officer Rouse did respond to requests for hearing. There are a couple of emails in the file where he said, these matters are continued under the agency's dockets until basically rulemaking has been completed. That was Hearing Officer Rouse's language in those emails as best I can recall. And there was no hearing because there was a moratorium in Broomfield on new permit applications, and they have to have their USR.
If I can continue, well, that actually is a great segue to my next question, which is, so is it your position that the moratorium can continue indefinitely and that Broomfield can refuse to consider taking action on Crestone's application for some indefinite period, and so that Crestone never gets a hearing?
No, sir. Moratoria, just like bans, are governed by Colorado Supreme Court cases. And the Fort Collins case, I believe, says pretty specifically that approved a moratoria of 12 months and raised questions of whether a moratorium of a longer period would be acceptable. It just depends on the facts of why the moratorium is being used. So, no. Broomfield is subject to reasonable constraints on the moratorium. I believe, and Mr. Sullivan will correct me if I'm wrong, that the moratorium is scheduled to expire on June 1? June 4th of this year. So it's not forever. It's basically a year.
And you don't think that Senate Bill 19181 changed the law in that respect?
On moratoria?
Yes.
Nothing comes to mind. I wouldn't want to comment on it without thinking through it.
Okay, great. So it's been now over a year since the permit was initially approved, and you're saying that it's reasonable for Crestone to have to wait at least another 6 months before Broomfield is required to take any action on Crestone's request for a permit, which is not to say that Broomfield will actually grant the permit, just that it would consider it.
It's not only reasonable, I think Senate Bill 19181 requires it, because Senate Bill 19181 allows the local jurisdiction to make the initial decision on where wells should be located. And I'll say to the Commission, Broomfield is under siege with oil and gas operations right now. So the moratorium is simply, or is partially, a response to intense drilling by extraction and other operators. So I do think it's reasonable, and I think that 19181 backs that up.
And you think it's fair to assume from your answer that that 181 is self-executing, that is, it's immediately effective, there aren't any rules required in order to implement the provision you just discussed?
19181 applies to all new permits and all pending applications. This was a pending application, so yes, it is self-executing, and it applies to these permits.
Just my final question then. So in your view, Crestone, as Ms. Jost put it, is stuck, right? Has no remedy?
It's not stuck. It's like any other, Crestone is like any other company. any other citizen of this state that is required to comply with the laws of the state. And the laws of the state have changed. We all know that. Crestone isn't allowed to go out and drill wells without permits from the commission. It doesn't have those permits. So I don't think it's stuck. I think it has to follow the law.
But it can't get a hearing on its permit application,
It can
either
get a
here
hearing.
or at Broomfield. It can't get a hearing either place.
It can get a hearing at the appropriate time. You asked the question of whether this was a forever moratorium and Crestone would be prohibited forever from having a USR or a hearing. The answer is no. No, they will get that. But in the meantime, Section 19181, I think, requires this commission to step back and apply the law, which allows Broomfield to proceed on the USR before the commission grants a permit.
Thanks.
Commissioner Overturf.
Thank you. I had some questions along a similar path for Ms. Jost. So I want to make sure that I'm understanding your client's position. So your argument is that because the permits were approved prior to being suspended, that therefore the provisions of Senate Bill 181 do not apply in this instance?
Thank you for the question, Commissioner Overturf. Can you hear me okay? Okay. I think that's an extension of some of the arguments that have been made. But in this instance, this is not a matter of semantics. This is not a typical permit that from our belief that Senate Bill 181 stated that the language of 181 was to be applied, and I've wrote it down specifically here somewhere, but on the date forward only and then to the determination of pending permits. Pending permits is typically viewed as a permit that has been in the queue, either not on a party's priority list or on a priority list, that has not passed completeness, or if it's past completeness, it has not gone through public comment or gone through the technical review of the staff, and therefore all of it is still pending. In our case, which we recognize is a very factually specific case and a one-off here, all of that review had occurred, and meaning that they were filed in June 2018, they passed completeness check, public comment occurred and was actually extended upon the request of Broomfield by an additional 10 days. Technical review occurred, additional BMP COAs were put on from Broomfield's request, and then those permits were approved. And so in the context of the law under Denver Buick, as well as the context of the APA, that law in place at the time in June as well as December should be what we're looking at here. What we are really asking is that the law really uphold the allowance for a hearing on the merits. I hate to get into the merits because this is not the purpose of this hearing. And I guess the only other extension of this that I would say, if I may, is that the context of this 15 months later is unfortunately frustrating from Crestone's perspective, because we do feel like we're in a box. We have tried every which way to get this in front of the commission as well as Broomfield. We have requested numerous times to have hearings in front of this commission, only to be met with silence. Now, Broomfield views this another way with respect to the continuances, but if Crestone did not agree to continuances both in January and in March, we would have had to be in front of you, and probably one of the first questions this commission would have asked is, did you try to work this out? Did you try to resolve it? Why are you in front of us had you not have done that? Secondarily, Crestone has not only tried to get in front of this commission, but we did try to get in front of the Broomfield Commission because we actually asked for an exception to their moratorium under the law as well, and we were told no. And so to have this continue to go on, we're not saying new BMPs, COAs, and mitigation measures cannot be placed upon these permits pursuant to the 305E2 hearing. That's actually what that hearing is for.
Right, so can I just, because that was actually my question. So when you say there's review and the review has been done, and that's why it's final in your position, you would agree with me, though, that the hearing that you're requesting that this commission undertake would result in further review and an opportunity to approve or modify or deny the permits that are at issue here, right?
That's your procedure. I mean, that is the purpose of the 305E2 hearing. Even though the approval is suspended, that does not mean that that approval did not happen. And so, and actually, under the 305E2 rules and the public hearing on it, I do hesitate to get into this because there is some of the merits in here. There are specific aspects that this commission can do. One of those aspects is looking at, are there additional BMPs that need to be put into place? Now, are those BMPs under 181? Are those BMPs under Broomfield's request? Some of those BMPs may be under Creststone's request, but that does not change the past, and that does not change the fact that these were approved 5 months prior to 181. We recognize this is a really unique situation. All we are asking is for the right that Creststone has under 305E2 for an expedited hearing on these matters in front of the commission.
So under the interpretation of the law that you have, that hearing would really be the only opportunity that Broomfield would have to modify the permit as it exists today. They would not have the opportunity to undergo their own review of the location and to impose their own requirements on the permit. It would only be the expedited hearing that was occurring in front of the COGCC.
Respectfully, I disagree with that statement.
Okay.
The reason being is because we still have to go through the Broomfield process. Broomfield has every ability to apply whatever they want on Creststone's permit in the local government realm. And just for a friendly reminder, the local government permit in Broomfield has been pending since February 2018, 2 years at this point in time. Creststone has been placed on hold by Broomfield because of they were reviewing their regulations and they would not press it forward. They then got caught up, as all of us have, with 181, have not pressed it forward. Creststone has submitted not only its initial permit, but it responded to 16 pages of additional information with about 1,000 pages of additional information to Broomfield. Nothing can now happen because of the moratorium. The moratorium was put in place in May, very soon after 181 was put in place, and was just recently extended to June, as you heard Broomfield testify to. Broomfield has every ability to deal with the siting, the location, all of that through its local permit process. This exception hearing, the merits hearing under 305E2 is not the end-all be-all of what Broomfield can do.
So if Broomfield, if we adopted your approach and we went through the hearing and we reapproved in your parlance the permits, and then Broomfield went through its process and it says, okay, we have our shiny new regulations, and our regulations say you just can't drill here. If you want to do this, you've got to do it somewhere over there. Then what would happen? Would you be coming back to this commission in order to then get approved?
I love the comments on this, and thank you for this commentary, because I can't speak to what Creststone would do in that situation, but from my context, if they went through the process after the moratorium was done, and who knows how long that process could be. It could be an additional year, 18 months, 2 years. And Broomfield denied that permit. That's probably not something that comes back to the commission. That would likely be something that's more of a judicial review in a court. I will, just for purposes of clarification on the record, Broomfield stated that it's under siege by oil and gas development. There are 2 operators potentially in Broomfield. Well, 1 operator we know, which is Extraction, and they have an operating agreement with Broomfield. They're not subject to the moratorium. The only other operator in Broomfield is Creststone, and it is 1 location, this Godel location, 1 and only ever location in Broomfield. The location is about as far north in Broomfield as you can be, close to Weld County. This location is within a unit that was approved by the commission, appealed by Broomfield. The district court upheld this commission's decision, and the moratorium is not against any other hundreds of operators. It's against Creststone. And so at this point in time, it's very hard to say, hey, we'd be back in front of the commission. Your rules are changing. There may not be a process to come back in front of you, but if Broomfield denies, then I would just say Creststone probably has bigger issues, and it probably doesn't involve the commission. Thank you.
Commissioner Boygan.
Ms. Jost, just to pick up on that theme for a minute, so let's say we grant your exception and you have your hearing, and let's say that the commission approves the permit with some additional BMPs. Don't you end up in court anyway? Doesn't Broomfield then challenge the action of the commission in issuing the permit on the ground that Senate Bill 19-181 requires that there be a local disposition before this commission take action?
Thank you, Commissioner Boygan, for the question. I don't really want to speculate on what Broomfield may or may not do. Given its past history, there's a potential for an appeal on that. But I would be very hesitant to have the commission not follow the law and not follow case law and not follow its own regulations with a what if as to may happen with respect to what Broomfield may or may not assert against Crestone. So I'm not dancing around your answer. I just don't want to speculate on that. So thank you.
Thanks.
Commissioner Messner.
Thank you, Mr. Chair. Just a couple of questions. I wonder, Ms. Joseph, I could ask you if you and Crestone acknowledge that Broomfield has regulatory authority within its jurisdiction over oil and gas operations.
Yes, thank you for the question. Crestone has never stated that Broomfield does not have regulatory authority. I think there are questions of what authority applies when, pre and post 181, but I think as evidenced in the record and as evidenced by the hearing today, Crestone has been very clear in the recognition of that authority because they filed a use by special review permit in February 2018.
Okay.
Thank you.
And understanding that, and my understanding of the situation is that really what we're considering here is whether the commission has authority to grant a permit application without a local government disposition. Having said that, do you, let me see how I would say this question. I mean, do you acknowledge that SB 19-181 requires that this commission get approval of a local government's permit prior to making a decision on a state-issued permit?
Thank you for the question. I really don't want to be boxed in here with respect to this because this is a case solely with Crestone. I would say that 181, as adopted on April 16th, 2019, does state that the commission has to have a local government disposition before the approval of a permit. However, in this instance, we already had approved permits that were just suspended in time. That does not make this a pending permit. And so I guess I would just make sure that I'm clear in saying that while 181 speaks for itself, the effective date is very important here along the lines of the APA and the case law in addition to that. If we were up here, if I may provide a hypothetical, if we were up here on a unapproved pending permit, say on a 303C application, and what that is if someone doesn't have their permits within 75 days, your rules allow an operator to come to the commission and say, hey, we would like a determination on this permit. Never having any approval, never having anything along those lines. That's a very different story under 181 at this point as applied to the facts of this case where we had approved permits in December.
So really your argument is whether or not this was a pending application or not. I mean, that is the gist of your argument.
Commissioner Messner, very respectfully, no. We're not arguing this as a pending permit. It's not. It's an
That's what I'm
approved
saying.
permit. And then just for purposes of clarification, when you started your commentary on the question, you said we're here if the commission can approve permits or not without local disposition. We're here on a hearing officer's order staying basically indefinitely this matter. So to me, that's a different aspect of why we're here today. So I just want to clarify on the record, what you're asking is actually extended from the purpose of this hearing, and the purpose of this hearing is to determine whether the hearing officer was in error, whether there were inaccurate legal conclusions. very respectfully, Attorney General can guide you on your questions with respect to the application of 181 in this instance, but this hearing is not here to determine that issue. This hearing is here to determine if Crestone can finally have a hearing in front of the commission.
Correct, but I mean, the gist of that argument is whether or not this application is pending or whether it is approved. And that, to me, is germane to this discussion as far as whether or not we're determining whether we have the authority to grant a permit application.
And I think if I may respond, and again, with all due respect to the position of what you think the gist of our argument is, really it's not a determination as to whether it's approved or pending. It's approved. The only reason we're here is because 305E2 is a suspension of an approval. That's your rules. That's the language. And so I don't want to continue to go down that road from my standpoint. I think you have your position on what you believe the argument is, and we believe that our argument is not completely in line with that.
Okay. Commissioner Hopkins.
This is a question I'd like to have both councils answer. And getting back to the approval versus the suspended permit issue and connecting that with SB 181, I'd like to have you both just present what you believe this permitting status is with the overlay of SB 181 and the Commission's authority to act on the hearing officer's recommendation.
Do you want me to go first?
Fine.
Thank you. Thank you for the question. Again, background when this, the permits, and by the way, this is 32 wells, I believe, were suspended in December of 2018. And those permits have never been issued. And the way the commission can know that they have never been issued and that they are still pending is that Crestone Peak does not have the right to go out and drill yet. They have to go through the local approval process. They have to go through comment on health, safety, and welfare. So the overlay is permits suspended, 19-181 comes into place. The law of the state of Colorado then became that the local government had the right to approve the location of permits if it assumed jurisdiction, which Broomfield has over these permits.
Thank you, if I may. Thank you, Commissioner Hopkins, for the question. I guess first off, for the record, I do want to think, I think we're getting very far afield of why we're here today. But in response to your question, the 181, the hearing is really not contingent upon local approval. It's not contingent upon 181. What Crestone is here doing is we are following processes. 305E2 requires a hearing. We cannot get the hearing, change in law or not. The other aspect is that 305E2 can allow us to present the merits on an approved permit. The plain language of 305E2 does nothing but tie to approvals. It does not state it gets kicked back to pending. It's just suspended until the hearing. And Commissioner Hopkins, I don't mean to dance around your question, but the question that was asked really just doesn't get to the heart of the matter. And the heart of the matter is, can we have a hearing under your rules that did not change, have not changed, by 181 for approved permits 5 months prior to 181? That's all we're asking, is can we get a hearing?
Just a quick follow-up. So am I hearing you, and maybe I'm mishearing you, that SB 181 doesn't have any impact on the whole process that we're involved with at this particular point and the local government disposition of the permits?
If that's what came out, that's not what was intended. We're recognizing 181's there. We have never shirked 181.
But the impacts of 181 as it applies to what we're talking about here.
The effective date of 181 is April 16th, 2019. There is Section 19 of the Act of 181 that states that 181 applies on the date forward or to determinations of pending permits. This is not a pending permit. So from our perspective, really the local disposition issue We have to get a permit from them. Crestone has put their hand up and has said, we totally understand that based upon our filing in February 2018. We're only asking for an application of your procedures to apply. We are asking for you to take into account the APA that allows us to proceed under pre-181 for purposes of getting the merits hearing, and we're just asking for that hearing. Thank you.
Commissioner Boygan.
Thank you. I also have a question for both counsel. I'd like you both, starting with Mr. Barber, to address the question of our Rule 532 and whether or not Crestone's exception can be heard, or whether our rule precludes it. And another way of asking that question is whether our rule is overridden by the APA. Is there any standard by which we can hear an exception to a hearing order's decision granting a stay? I think, Mr. Barber, if I heard you correctly, you said there was an abuse of discretion standard that could be applied. So I'd like to hear both counsel address that issue.
Thank you, Commissioner Boygan. 532A is the applicable provision, and it has not changed since the Crestone Peak our APDs were submitted. And 532A states that an interim decision is one that is issued after an application is set for hearing, and a recommended order, which is 532B, which is a different component of Rule 532, is a written decision by a hearing officer after oral statements, written statements, the evidence and the arguments presented at the hearing. So a recommended order, I think, is what Crestone is arguing has happened here, and it hasn't. Our position is that this is simply an interim decision because there has been no hearing, there's been no evidence, there's been no testimony. This is essentially a procedural determination by a hearing officer that there should be a stay, and it's reviewed under an abuse of discretion. It is not a recommended decision, or recommended order, excuse me.
Can I follow up? Isn't Crestone's position that this is an interim decision or an initial decision under the APA, and that overrides this or applies in addition to this rule? And isn't their position that if they can't get their application set for hearing, therefore the rule isn't applicable here? They're challenging the refusal of the hearing officer even to set this for hearing.
Well, first of all, Commissioner Boygan, this matter was set for hearing twice, and Crestone agreed to continue those hearings. So it's not accurate, I think, to claim that Crestone's never had the right to go to hearing. Second, the hearing officer can and will set the matter for hearing once the rulemaking in Broomfield takes place, once this commission finishes its rulemaking. So at that point, the hearing officer can give a recommended order, but it hasn't happened. I don't know if that answers your question or not.
That's your answer. I'd like to hear Ms. Jost's answer.
Thank you, Commissioner Boygan, for the question. With respect to Commission Rule 532A, I just want to read it verbatim. It states that interim decisions are issued after an application is set for hearing, but are not recommended orders that may become a final decision on the commission. This matter has never been set for hearing since May 2019. I know Broomfield keeps going back to these continuances, and Crestone has never said they did not jointly agree to the first continuance because we were in discussions. We were in potential resolution talks. If that would have been forced to hearing in front of you, respectfully, you probably would have told us to say, go step out in the hall and continue your talks. Crestone did not want to come in front of the commission and look negatively that they weren't trying to work with a local government. Now, the May hearing, that was a forced continuance because the hearing officer did not tell the parties, including Broomfield, until 3 business days prior that this was on the docket. Broomfield stated, we cannot be ready. Crestone said, if you can't be ready, we'll agree to a continuance. So I just want to make that clear. For purposes of Rule 532 for a recommended order, recommended orders are made pursuant to your own rule after the merits of the case have been had. This cannot be a recommended order. We've never been able to get in front of you to have the merits of the hearing in this case. Under the APA, 24.4.10, let me get to it. 105, Section 14 provides, for the purpose of a decision by an agency that conducts a hearing or an initial decision by an administrative law judge or hearing officer, an exception can be filed. Please remember, Crestone had to file its an exception under the APA. It is an obligation. It is not a flexibility that we could come back later and say, oh, hey, by the way, we have to file this. Crestone would have waived by law. And so, Commissioner Boygan, for purposes of your question, we do absolutely believe we have a right to be here for the exception. We do believe that the APA kind of overrides the rules at this point in time. And again, we would request a hearing based upon your rule 305E2 that requires, it is a shall, an expedited hearing on a suspended approved permit. Thank you.
May I add something, Commissioner Boygan? Thank you. In our objection to Crestone Peak's exceptions, we did address this argument of the APA. And what the case law says is that an initial decision is, quote, a decision made by a hearing officer or administrative law judge which will become action of the agency unless reviewed by the agency. And then the case of Lampier versus Department of Health says an initial decision contemplates a decision on the merits. So we don't have a decision on the merits. So the APA does not apply. At this point, at least. It may at some point, but it doesn't apply at this point.
Any more questions? And I just want to remind the commissioners that, you know, the only issue for the commission to decide today is whether the hearing officer's decision for stay was correct. So I just want to make sure we're all on the same page with that. Commissioner Messner.
Thank you, Mr. Chairman. I'll make a motion that the hearing officer's staying proceeding should stand.
Is there a second?
Second.
There's a second. Any further discussion? Commissioner Boygan.
Thank you, Mr. Chair. I'm going to vote against this motion. I am troubled by this case. I recognize that Rule 532 was intended to prevent interim decisions coming before this commission. I do view this as an abuse of discretion. I think that there has been an unexplained absence of any action by this commission over a period of 6 months following the second continuance, which Crestone says was forced on them. So, you know, maybe, maybe not, but there's been a period of at least 6 months where nothing happened. Broomfield has imposed an indefinite moratorium on taking any action with respect to this application. Crestone just simply wants to get the hearing that it thinks it's entitled to. And I'm not expressing any view on what we would or should do in that hearing if Crestone's ever able to get it. But I'm troubled by the fact that they can't get a hearing before either this commission or Broomfield on their application. And so I'm going to oppose the motion.
Commissioner Overturf.
Thank you. I just wanted to provide a bit more context about why I seconded the motion and why I will be voting in support of the motion. First, I don't believe that this is properly before us on exceptions. I don't believe that an order by a hearing officer or an administrative law judge granting a stay or any other type of procedural kind of case management orders are recommended decisions that we should be taking up on exceptions. And so that as a threshold issue, I think is a reason why I would vote to uphold the hearing officer's decision. But I also want to say that I don't agree with Crestone's interpretation that these permits were approved or were somehow that the commission had taken final agency action by virtue of that initial approval, and that therefore the provisions of Senate Bill 181 don't apply. That approval would not be and was not final until this commission conducted the hearing that's set forth in our rule and entered a decision after that hearing. And thus, I believe that that Senate Bill 181 does apply, and I agree with the hearing officer that Broomfield has the right to make the initial determination regarding the drilling and location of wells. Granting the stay, I believe, is appropriate because that's what 181 requires, and because it serves our interests of administrative efficiency to delay any hearing that we would conduct until Broomfield has had an opportunity to make its determination about these matters. So that's why I will be voting in support of the motion.
Thank you, Commissioner. Any further comments before we vote? Seeing none, all those in favor of the motion before us signify as aye.
Aye.
Any opposed, say no.
No.
Okay, the motion carries. Thank you so much. And we are going to take about a 10-minute break before, and next up we will have the staff presentation on the draft mission change rules. So let's see here. Let's come back at 10:30. Okay, thanks.
Thank you very much.
You back on? Are we live? Okay. COGCC meeting will come back to order, and please have a seat. Thanks, everyone. Next up, we have a presentation with the draft mission change rules, and I believe Director Robbins will facilitate this. So, Director Robbins, whenever you're ready, the floor is yours.
Okay. Thank you, Chairman Gibbs. We're getting the PowerPoint slide up and running, it looks like. Here it is. So thank you for that. We're in kind of a little bit of a unique perspective here today. Normally when we undertake rulemaking, you direct rulemaking to happen, we create draft rules, we publish draft rules in the Colorado Register, and then we get into a formal rulemaking process. As I mentioned yesterday, given the enormity of what we're doing, we've undertaken this process in a little bit of a different fashion with the publication of the Mission Change White Paper several months ago, which generated discussion among stakeholders about what we're doing. And then here more recently, within the last couple of weeks, we've published straw dog rules. It's dog, Commissioner Overturf, because I'm from Georgia, and I can call it a straw dog rule. And I actually looked it up on Wikipedia, and you'll see in just a minute what straw dog actually means. We have to have levity in all that we do in order to ensure that we show up to work each day. Anyway, with the publication of the straw dog rules, we now have notions or potential conceptual rules that are out, and we were originally supposed to undertake wellbore integrity yesterday and today, and then that didn't happen due to a clerical mishap. But that did provide us with this opportunity today to talk with you, to introduce you to the straw dog rules, which is not something normally that would happen. Normally we would have rules that are promulgated, and then we would be in a hearing process and we would be taking formal stakeholder. But we've taken these last several months to undertake informal stakeholder rules with regard to the concepts of the white paper and now the conceptual rules that are outlined in the straw dog rules. So that's what we're going to do today, is we're going to walk through what we have generated and allow you to ask questions about that or have discussion about what we've put forward. Before I get into the specifics, and as I mentioned yesterday, one of the very positive developments that I am excited about is that the Commission staff has been just instrumental in rolling up their sleeves and having a can-do attitude in terms of helping us redevelop the regulatory framework at the Colorado Oil and Gas Conservation Commission. So I have with us here today all of my senior managers. They have subject matter expertise in regards to all of the things that we've placed out there with the rules, and they are available to help answer specific questions if you have them. All of these individuals have been intimately involved in whichever area of the rules that is akin to what they do on a daily basis. These individuals, these managers and some supervisors have also been involved in the other part of this undertaking, which is we are taking this opportunity to consolidate and recraft our regulatory framework so that it's not what it is today, which is not intentional but sort of accidentally. We have rules that are kind of scattered throughout, and so we've tried to reorg those so that it's a better overall regulatory framework that's understandable. And we are, Commissioner Borgen, looking at you, finishing up the crosswalk to help folks understand where things may have changed. And we are also going to be looking at the whole concept of the doing red line with that. So with that, I would move to the next slide. And this is our time frame. As you know, we created the administrative law judge rule in July, flow lines in November. Wellbore Integrity is going to be here on March 25th and 26th. And then mission change, cumulative impact, and alternate location analysis, sort of the mega rulemaking, is scheduled for late April and throughout the month of May. The professional commission gets seated on July 1, and then they have work to do as well in terms of the other rules mandated by 181, a rule around worker certification, financial assurance, and application fees. And I believe that we will see the professional commission revisiting some of the rules that, sort of we've put together to make sure that everything's working correctly. With that, wanted to kind of provide, aspect to what we're doing. There are, I think sort of two types of rules that we're approaching. One is sort of the technical, the specific, the concrete. Flow lines is a specific discrete area that you tackled very well. Wellbore integrity is a similar sort of technical discrete area about underground protections with regard to how oil and gas is developed. And then, as I mentioned, we have sort of the big picture reorganization. An example of that is the new 400 series straw dog is the operations rules, and operations rules currently are sort of scattered throughout our rulemaking or our rules. And so what we've done is we've taken a lot of those operation rules that may have been in like 600 or may have been in 900, and we've put them into one rule under the 400 series. The other type, as I mentioned, sort of big picture reorganization is sort of the breaking new ground. The mission change is a new mandate for us, moving from fostering to regulating in a manner that's protective of health, safety, welfare, the environment, and wildlife resources. The other two that are on the screen, cumulative impacts and alternate location analysis, those are topics that are new to this commission. This commission has not historically had an ability to look at the potential of cumulative impacts from oil and gas development, in particular in populated areas, or the concept of looking at different locations for oil and gas in populated areas. And so that's sort of the second sort of type of rulemaking that we have. So just to briefly touch base on wellbore integrity, that's set for March 25th and March 26th. Big kudos to my staff and to our stakeholders. The wellbore integrity rulemaking is actually something that predated my being director. We were under a order from former Governor Hickenlooper to revisit the wellbore integrity rules. There is a group, Julie Murphy, SOGR stands for State Oil and Gas Regulatory Exchange, thank you. That group of independent professionals did an analysis of the wellbore integrity rules and provided that to the commission. That regulatory analysis was referenced in Senate Bill 181, and we were invited to implement that regulatory analysis. Certain environmental groups and certain industry groups got together and worked up a red line to our wellbore integrity rules. I want to thank our engineering staff for taking that and then reviewing it and coming up with a proposed red line rule for us on wellbore integrity. In large part, I think we have fairly consistent approach to this, and so we will be bringing wellbore integrity to you in March 25th and March 26th, and we're hopeful that that will be a positive rulemaking that we will, move forward with. Next is, we've been asked, why roll all the other rules into one mega rulemaking? We had originally posted that we would do mission change in 1 month and then cumulative impacts in the following month, and then at some point we would do alternative site analysis. But having published it that way and in taking stakeholder input, we quickly there was actually kind of consensus around this, is that you really can't talk about mission change without thinking through the concepts of cumulative impacts. and it's hard to envision creating an alternate location analysis process without also sort of thinking about cumulative impacts. And so pretty much there was consensus from stakeholders that despite the fact that it seems ominous and large, we really should be tackling all of these concepts in one rulemaking. And so I talked to you yesterday about the fact that we will open up a rulemaking we will publish for the rulemaking in March. We'll open up the rulemaking on April 29th, and then we'll take things sequentially from there. We also are taking this opportunity, as I mentioned, sort of good government changes. We're taking the opportunity to reorganize the rules, to consolidate the topics into discrete rulemaking topics. We're eliminating duplicative, irrelevant, or unnecessary requirements. We are taking this opportunity to work with local governments to try to create a rule or a set of rules that will work with the various approaches local governments are taking in terms of their implementation of their new authority under 181. We also are working hand in hand with CDPHE so that we're not creating duplicative or unnecessary rules in that regard. So straw dog rules, earlier this month we published this. I looked it up, and straw dog means a brainstormed simple draft proposal intended to generate discussion of its advantages and disadvantages and to provoke the generation of new and better proposals. So having found that, I had to use it.
Source, please, source of that definition.
Wikipedia.
Okay, so it's authoritative, okay.
It's authoritative.
Did you just inserted it?
Yeah, I did not. I added to it. The goal, though, was, as I've mentioned several times, is to generate discussion. And the straw dog rules have definitely done that. We have been, my staff and I have been meeting with all sorts of stakeholders. We're getting information into our email portals. We're meeting weekly with industry groups, with environmental groups, with local government groups, with folks from the West Slope, with folks from the Eastern Plains. So it has generated a lot of discussion, and I'm hopeful that it will allow for the generation of new and better proposals. And we're receiving a lot of proposals as well, which is really, I think, good. It's, what we try to do here in Colorado. And so that's where we are. And so with that, we'll start walking through the specific changes that are being made. And I would encourage my staff to help me stand up. You're subject matter experts on a lot of this as well. So just starting at the beginning with the 200 series, this establishes that there will be compliance with our rules and ensures that contractors and subcontractors also comply with rules. One of the things that I found in my 1 year and 2 month tenure as director is that we need to make sure that the folks that are operating under an approved Form 2A know what the conditions of approval of the Form 2A are, or that they understand the best management practices. And so I wanted to highlight that in the rule series. We also, in the new rules in the 200 and the 300 series, we're formulating the recognition of local government authority and we're working hard on establishing mechanisms in our rules so that we can have a good regulatory framework with the various local governments that are implementing their authority. They're doing it in different fashions, and so creating one rule at our commission to accommodate that is a little challenging, but we're having really good discussions with operators and with local governments about how to be successful in that front. We also are addressing transfer of permits in the 200 series. This issue arises because under current scenario, transfers in general from one operator to another operator occur without a lot of COGCC oversight. And we want to make sure that we are involved and look at and ensure that financial assurances are in place when one operator transfers to a new operator. we are working with operators around this topic because this gets into private contractual contracts between operator A and operator B, and so we are working around the ability to establish a method for this to occur that allows for private contracts to be honored. And so this is an area that I think the proposed rule has generated discussion, which is helpful. And so we hope that by the time we get to mid-March, and we will have something that is a better proposal from the straw dog. So moving forward, another large-scale proposal is moving away from the sort of truncated approval process that happens at the State Commission, where there is a drilling and spacing unit on the one hand. There's a pooling order that also has to be approved at some point in the process. There's a Form 2, which is the downhole oil and gas well permit approval. There's the Form 2A, the surface location approval. And all of those happen at various aspects. And so we've created a template for a one permit process, an oil and gas development plan. The one permit process still has within it those various types of elements that need to happen, but we're trying to weave them all into one process. One of the things that we are attempting to do with this is to do away with the concept that the first operator to file a 2 or a 2A is somehow or another, that filing in and of itself has some entitlement right. That's not what I think 181 is telling us to do. I think 181 is telling us that we should be looking at development of the surface and the mineral estate in a manner that's protective, and whether you filed first or not should not be part of the equation of whether it's protective and whether it ought to be approved. In discussion with our stakeholders, I think there is uniform agreement that this concept makes sense. The straw dog is helping us receive input to this, and we're certainly not where we will be when we get to a rule to publish and then debate in the formal rulemaking process. In other words, we've daylighted the idea. We're receiving a lot of information about the pros and cons of how we're doing it right now, and I think we will be moving forward to a better regulatory approach of a single process over the course of the next several weeks. So, as I mentioned, this one process is also a protection-based permit review. Ensures approved permits protect the public and the environment and reflect the best plan for development. We establish in these rules denial criteria. That is somewhat new. I think the Oil and Gas Commission takes a little bit of a beating that they've never denied a permit, because in fact, there have been many, many instances on my watch and on previous directors' watches where a proposed development is not necessarily approved, and instead there is a, you need to go do this better. And so a proposal comes to us, it doesn't get approved, and then the operator comes and does a reproposal that is better. And so that's the old format of doing business. The new format establishes that we do have denial criteria. If you don't meet our rules, then there could be a potential for denial. The permit applications must demonstrate that proposed operations will be protective. That's right out of 181. And then we have within the rule the specific operation plans. So a dust mitigation plan, a light mitigation plan, a odor mitigation plan. None of that is prescriptive or specific. You have to do it this way. Instead, it lets the operators provide to us their best management practices for accomplishing oil and gas development in a manner that is protective under Senate Bill 181. Seismic, this was new to me as director, and it was one of the things that I had to address within the first few weeks of being on the job. We had an operator that did a seismic operation, and the folks in the neighborhood didn't know about it. And so our team has come up with regulatory oversight provision for seismic operations, requiring that notice goes to local governments and to residents, and we've got a conduct operations around seismic activities. I just think that makes sense, and so we're taking comment on that rule. The 300 series also empowers landscape or comprehensive level planning. This is a topic that, again, I think there is fairly uniform consistency around. This is a good idea. It makes sense under 181. Looking at oil and gas development away from a one well here approach versus looking at an area and looking at potentially, and I'm making up numbers, but 20 oil and gas locations with several hundred wells, and looking at that comprehensively through one process. The oil and gas development plan idea, the single permit idea, doesn't expressly state this, but it does allow for an oil and gas development plan to be a one location, or it could be a large area, and it could be 20 locations. There's some incentive to do a large areas and multiple locations, because under the idea that we have out now, the oil and gas development plan would not be approved administratively by the director, but instead would be reviewed by the director, and then a recommendation would go to the professional commission. So there is a hearing on an oil and gas development plan. So that establishes that there would be an incentive for operators to potentially have one hearing on 20 locations from a comprehensive perspective versus having 20 hearings on each individual location. So we think we've built in some incentives for looking at things comprehensively, looking at things from sort of cumulative impacts, and using the oil and gas development plan as a landscape level planning tool. Air quality, we forwarded this out Friday, is that right? Or just recently, or Tuesday, just here in the last day or so. It's Thursday now, I know that. And we wanted to flag this for you. This is new Rule 303C18, establishes that operators will submit estimates of pre-production and production emissions of air pollutants of concern. And 314D11, operators will submit estimates of pre-production and production emissions, et cetera. So these two rules are new. We released this a little later than the other straw dogs because we've been working hand in hand with CDPHE to ensure that what we've produced is not duplicative of some of the air emission elements that they're doing. We believe that this is an important concept for discussion. It starts the collection of data on pre-production and production phase emissions of air pollutants, including greenhouse gases. This will help inform future commissioners as they advance cumulative impacts in the future. So getting this data is an important first step. It also helps inform my environmental staff on best practices. This is a model that BLM uses, and so we floated this out for consideration by our stakeholders. Next. So moving to the 400 series, this creates an operations and reporting rule series. This is where we have taken all the operations rules and put them into the series. Using the crosswalk, which is going to come out, you'll be able to see where things have moved from other series into the 400 series. Another important component of this is this eliminates the GWA wellbore spacing units. We don't believe that out or that permitting approach, which is administrative, and which you heard about over the last day or so, that it maybe doesn't make sense in a post-181 world. This also creates transparency for mineral owners. It weaves into the single permitting process. A third component of 400 series, it requires a location construction report. This provides details of the final location build-out. It facilitates inspections. It helps our field inspectors and it deals with location closures and reclamation. So another good government rule that we think makes sense on the 181, post-181 world. Another element of the 400 series, it strengthens the public water system protections. We've worked with the Water Quality Control Division on these rule revisions. This is increasing the area where sampling is done to ensure water aquifers are protected. This has certain prohibitions of chemicals in most sensitive areas. As an example of getting down into the weeds, we also have been working with the West Slope operators on this. There's a lot of reuse of water on the West Slope, and so we recognize that reuse of some of that water may have some of these chemical constituencies, and so we're working on thinking about an out for that so that we're not inhibiting the good concept of the reuse of water on the West Slope. So that's still in discussion. Noise, we've updated and created meaningful noise regulatory requirements. Operators have to now submit a noise mitigation plan. A lot of this is what operators are doing anyway, and we're just codifying that in the rules. We're addressing the C-scale noise. Again, a lot of this is previously, these are standards that were met. And then we also are allowing in this new noise protocol that we need to address and understand that ambient noise exists, and so how do we address that in the noise plans? So again, as I mentioned, we have different sorts of plans. So there is a lighting plan, ensure that BMPs are in place to minimize light. Odor plan, within 2,000 feet of a building unit must use BMPs to minimize odors. We're having discussions with local governments around many of these elements. Many of these elements local governments are involved in. I think odor is like a really good one. I mean, that's a welfare sort of thing. It is a problem that should be addressed. It has some aspect of local government being involved. It also has some aspect of engineering and science that my engineers understand, what type of mud can be used and, should there be an amplified level of that. So we're working with our operator stakeholders and our local government stakeholders on a lot of these issues so that there is not a need for duplication, but that we can also ensure that we're setting a positive regulatory environment to address these issues. Standing. So now I've moved to the 500 series. We heard loud and clear from a majority, if not all of you, at the ALJ rulemaking when folks wanted to talk about standing, and we said, we want to talk about standing, but the ALJ was not the time to do it. So we have straw-dogged out a standing proposal that certainly broadens who can engage in COGCC hearings. We've defined a term, affected persons. This is a broader standing requirement than that which is limited in current standing requirements to a fairly small subset of persons who receive notice. But we also are attempting to create a standing definition so that we don't end up with everything being challenged by everyone. We want to establish standing that is meaningful, that establishes that folks that have potential negative impacts can be involved, whereas not bogging down the system where you have standing that's too broad. We're receiving a lot of comment about what we've proposed, and we look forward to continuing that discussion. We also have addressed enforcement. We're attempting to streamline enforcement procedures and clarifying liability issues relevant to operators and operations. Moving to the 600 series, again, a lot of this was rules that were sort of scattered about, and so we've tried to put them all within this safety and facilities operations rule. We are strengthening our drilling safety requirements. We are addressing in this tank inspections, signage, testing of tanks, mechanical conditions, fire protection. there's a lot of meat in this rule, and we're getting good feedback on the proposal that we have floated out. 600 series also requires greater safety measures to be taken to avoid impacts from hydrogen sulfide gas, which is a scary thing. We've codified the BLM H2S gas principles into our rules for greater worker protection. We are strengthening our groundwater baseline sampling rule. We're basically taking Rule 609 and making that applicable throughout the state, which is the higher level water quality rule that we have in place, and making sure that it's applicable throughout the state. 800 series, I am definitely outside of my surfboard expertise on this. This has to do with underground control well rules, and my staff has done a good job of essentially, from what I gather, codifying a lot of the good practices that we have in guidance and codifying that into the rule. And so we're taking stakeholder feedback on that as well. The 900 series, this requires operators to prevent pollution from spills and releases. This basically is strengthening our rules around spills and releases. It's requiring closure plans for all oil and gas facilities, not just pits. Requires exploration and production waste management plans. So basically strengthening our rules in these areas. Again, it requires all pits to be lined, requires operators to submit water quality analysis for produced water, and must report all spills that threaten waters of the state's public water systems, people, or wildlife. So again, taking the requirement that we be more protective and ensuring that our rules are reflective of that mandate. Rule 903A and B are procedural rules. This is addressing venting, flaring, and emissions. We're taking rules that we have and consolidating this into this one area. The general theme here is that if you are bringing natural gas to surface, we want you to get it into a pipeline. I'm sure we will be taking a lot of stakeholder input into this rule, but doing that and ensuring that natural gas is not vented or flared has environmental benefits. It also has benefits to mineral owners because we're not wasting that resource. We are coordinating with CDPHE. We have created in 903A3 a process of how to address inconsistencies between our rules and CDPHE rules. We are also establishing that we ought to have flaring. If flaring is going to occur, then we ought to ensure that people are aware of it, that local governments are made aware of it. When folks, by happenstance, see a large flame, they get nervous. But as with everything, if we have information out to folks about that, then that nervousness goes down as long as they know that it's being done in accordance with rule and in accordance with safety requirements. 903C and D are pre-production rules. It deals with drilling emissions, capturing gas while protecting safety. These are substantive standards for venting and flaring. The 903C is with regard to drilling emissions. Basically, the rule requires best management practices to capture gas as best as possible with safety outs. We are working with CDP to coordinate this rule. This also is going to require green completions for some but not all, expands green completions to all rules. So, and basically at the end of the day, as stuff is coming to the surface, we want to capture that gas and route it to a pipeline. And we are restricting the flaring of saleable gas. So these are some important concepts. We were excited to have finished up our coordination with CDPHE over the last several weeks, and we have pushed this out, and we are receiving stakeholder feedback around this. I think I would get back to the concept of straw dog. These are concepts. We received some negative feedback when we just did a mission change white paper, and folks are like, we want to see rules so that we can really comment. So we've done that. But I get back to the Wikipedia definition. The straw dog is supposed to allow for folks to present us with better rules. And so hopefully folks that are listening understand that some of these new concepts around flaring and venting and gas, et cetera, that we are wanting to hear back around these ideas from all of our stakeholders within the state of Colorado. And then we created Rule 903 around emissions during production. Again, sort of a prohibition on venting and flaring, except with certain limited exceptions, upset conditions, loadout, wildcat wells, and kind of other situations with director approval, with the understanding that those variances would not be granted unless it's consistent with protection of health, safety, welfare, and the environment. If venting and flaring is going to occur, we created a mineral owner notification provision so that mineral owners would be aware of the fact that they're not receiving royalties for gas that is vented or flared. We think that's an important concept. And this also addresses, this new rule addresses emissions from pits. Gas capture plans, we've created a rule. Other states are doing this. This basically is telling operators that you need to submit a plan about how you're going to connect to a gathering line, and then under that plan, you will prove that you have connected to a gathering line. And then we created a rule for discussion around air monitoring. This applies to new facilities in high-density residential areas. We are requiring continuous monitoring of VOCs in these specific areas. We don't have a specific proposal. It's all going to be done on a site-by-site basis. This is basically in the current urban mitigation areas, or UMAs. How does this work? Each site is sort of unique. And so under the Form 2A, we would create site-specific monitoring plans. It would be monitoring for pre-production and production. But if the operator can show that there are no negative emissions, then during the production phase, they can seek an out so that they don't have to continue the monitoring. We think that this is a good idea that deserves scrutiny. We've heard from some of you and from stakeholders that we should be exploring this. And so this rule is floated out as a straw dog. So then on cumulative impacts, Rule 904, and this again went out on Monday or Tuesday, we can't remember which. But basically what this rule is doing is, and it's almost not a rule, it's just a good idea, is that we suggest to this commission that you codify 904 and you tell to the professional commission that you should undertake studies. You should undertake studies around greenhouse gas emission, around hazardous air pollutant monitoring technology, and around hazardous air pollutant emissions. And that those studies should then report back from the director to the professional commission, and then that would be an ability for the professional commission to advance cumulative impacts 2.0. You would then be in a place to be able to determine what should we be doing here. So we think that gathering and establishing by rule that we should undertake these studies is a good idea. We're going to be working hand in hand with CDPHE on these issues as we address this important topic. And then finally, we still have some rules under development. Wildlife is an important component to Senate Bill 181. We are to regulate in a manner that's protective of all the other things and wildlife resources. Part of this is we need to further, so there's sort of two parts to this. One part is under the 300 series, we have a consultation provision with Colorado Parks and Wildlife. And we have been working on how to make that better, how to make that a good consultation provision for 2020 and beyond under Senate Bill 19181. And Chairman Gibbs, we've had a wonderful working relationship with your other department, CPW. We are sort of at the closing out on getting a straw dog out on the consultation provision with CPW. We also have the 1200 series, which is our wildlife series. And we are working with CPW and our stakeholders on that as well. It's not getting short shrift. It's just we have a lot on our plates. And this is another one of those areas that's kind of like singular on its own, an issue that we need to address. And so I'm hopeful, Julie, nod your head if I'm right, that we will have a straw dog out on wildlife, on 1200, and on consultation here shortly. Soonish, Ms. Murphy said.
Yeah, thank you, Director Robbins. And that's, very important. Looking around the room, too, a lot of folks are following the wildlife rules and regs. I want to direct your staff to get that out the door as soon as possible for the straw dog, and it's definitely a high priority for the administration and the department, and really appreciate your staff working really hard with your sister agency, CPW, to get that out for public comment as soon as possible. Thanks.
Appreciate that comment, and again, it is getting the needed attention, and we are hopeful to get something out for public comment soonish, according to Deputy Director Murphy, who's running lead on that. So just back to the calendar, we've got these hearings are scheduled. This is 10 days in late April and May. We hope to complete the rulemaking by May 29th. We have suggested to you informally that you should also not make plans for early June. We just need to be cognizant of the fact that this is an enormous lift, and we're going to have a lot of attention. We're going to have a lot of parties. We're going to have a lot of pre-hearing statements. It's important that we give this the due regard that it needs. So again, we're hopeful that we would get this through May. It may take into early June. Just procedurally, we've been talking internally and with stakeholders that we would likely ask this commission, when it votes on the rules, to make a specific effective date, as opposed to just letting the effective date roll out based upon publishing notices, but make a specific effective date of probably toward the end of August, early September. That would then give the professional commission a chance to get seated, get trained. It would also allow my staff and I to change the guidance documents. When you create a statute, you implement it through rules, but the day-to-day business is done, a lot of it, with guidance documents about what is meant by this rule and how do you comply with it and what's the form that you file, and we need to possibly change, we'll need to change our electronic forms. So there's a lot that has to happen at the commission between the date that we know what the rules are going to look like and the date that we turn those rules on. In discussions with stakeholders about this concept of maybe allowing for a period of time for transferring from the old protocol to the new protocol, everyone's kind of in agreement that that makes sense. That way, when we are moving forward with a new regulatory protocol, we're not stumbling out of the gate, but we've got everything ready to go, and operators will know how to move into the new regulatory framework. Stakeholders will know how to be involved in that new regulatory framework. So with that, we found a really pretty new picture to put with our thing. So I and my staff are here to take questions from you. And I've got everyone else here. I touched upon this enough to where hopefully I didn't stumble, but my subject matter experts are here if you've got questions about any of the concepts that are thrown out there for discussion.
Questions? Maybe I'll start out. When it comes to error monitoring of continuous VOCs, you mentioned urban mitigation area. Who decides if there's an urban mitigation area and whether or not it's within a geographic area? Local government, CDPHE? How's that determined, I guess?
Yeah, maybe I'll let one of these fine people speak to that a little bit in a little more detail.
Yes, thank you, Director Gibbs. This is Assistant Attorney General Joel Miner. You'll see in the regulatory language, Rule 903 G1, that there is a specific density of building units and high occupancy building units within 2,000 feet of the proposed oil and gas location. And the reference to urban mitigation areas means not that we're using the exact same definition as our current urban mitigation area, but rather using the same density of building units and then expanding that out to a radius of 2,000 feet. So if you look at our current definition of an urban mitigation area, you'll see that it refers to a certain number of building units in either one direction or in a full circle around the site. And we are using that same density, just expanding the radius slightly. And I don't know if Mr. Dronlo wants to add anything, but looks okay.
So you could have a certain geographical area that it's not considered this region now, but with new development, it could become one. So there's, yeah.
That's correct, but Rule 903 G1 only applies to future development. It would only apply to sites, I believe, as currently written, that are proposed 2As submitted after, I believe, August 1st, 2020, understanding that, that exact date is likely subject to change. That's just a starting point.
Commissioner Messer?
Thank you, Mr. Chairman. Just a couple of questions. Thank you very much for this, and I've made it about 3/4 of the way through the different documents at this point, and I think they really highlight, I think, some of the things that I thought were important to be included in there, and so I appreciate that very much. I did have just a couple of questions because maybe I'm missing them, but where are geologic hazards or a narrative regarding geologic hazards and the different permit, the one permit process we have located, in the new rules, or is there an analysis of geologic hazards as a part of our permit process now?
Ms. Murphy's going to tackle that one. Greg?
And it could be. I was going through it, and I just was.
Yep.
I couldn't. Pinpoint.
Some of my staff are saying that it's still a part of the 2A and the 2. People are moving around. And to the extent that we're not able to specifically answer a question today, we can get back to you.
Sure, and
with
that's
that
fine.
Sort of information.
Yeah. And along those same lines, some of the things that I've found really important in reviewing oil and gas permits at the local government level are around impacts to roads and transportation and those pieces. And I do know that there's a little bit in here about that as far as certainly having local government input on that. I didn't see anything in there as far as any kind of referral to CDOT, though, and any impacts to their infrastructure systems, and I didn't know if that was something that was considered important or not as a state transportation agency. So,
yeah, we've not made substantial changes with regard to impacts to local government roads or state highways. That is something that historically we've sort of defer to the local jurisdiction. Mm-hmm. That's it's their roads in a large extent. I know local governments have referrals to CDOT during their process, and so I think that's part of this reestablishing the intergovernmental relationship between the state and local governments and recognizing local government's authority. And historically, I think operators have done a good job of going to the impacted local government and creating a transportation plan that is informed by the local government as well as CDOT if CDOT is implicated for that.
Okay.
And so that probably is one of the areas where there's not significant change.
And the onus then being on the local government. And I appreciate that because local governments, in my opinion, should make that a significant part of their review process. So, that's questions that I had.
Commissioner Eaton.
Great, thank you. First of all, I wanted to thank you all for addressing the wildlife issues and looking at the relationship between whatever changes you make at a process level in 500 series with the 1200 series. And I think that, being strategic about that is important. So I'm looking forward to seeing what that looks like. I guess I wanted to go back to your request for delaying the implementation of the rules and just better understand what happens in between the time that we finish rulemaking and the rules go into effect in terms of the applicability to permits and things that are filed during that interim period.
That's an excellent question, and I should have covered that when I went over that part. Basically, what would happen is we would maintain the current status of permit review, which is permit review under our current regulations with application of objective criteria.
Okay.
So that would basically just remain in place for that additional month or two. We operate with the operators on their priority list and what wells are important, and we approve them based upon, or not approve them based upon whether they satisfy appropriately 181 under objective criteria. And so that would just remain in place for that additional month or so while we get up and running with our guidance, et cetera, and then turn on the rules at the appropriate time. This also would give us the opportunity to be pragmatic about the backlog that we have in terms of how we would address that in a go-forward position with the new regulatory protocol.
Okay, that's helpful.
Yeah, Commissioner Boygan?
Thank you. I'm, at this point, concerned about process and managing all this. It's an amazing, overwhelming job, and you've done an incredible job so far. The concern I have is we have roughly three-ish, let's see, March, April, May, maybe June, 4 months to get this done. You're basically rewriting the entire rule book. I think it's not realistic to think that we can get through the rulemaking in the days that you've scheduled. I think it's going to require more. And I'm concerned about how the process is going to be managed. If we're going to be hit with pre-hearing statements covering all of this, or whether it's going to be broken out in some more absorbable way, I think you're caught between wanting to consider all of this together because there's so much interrelationship on the one hand, and on the other hand, making it manageable to address. And so I guess I'm wondering how you plan to manage the actual rulemaking process in order to not only get through it, but to enable us to deal with it in an intelligible, realistic, and manageable way.
Thank you, Chairman Boygan. I think that is a very, I think that, Commissioner Boygan, you're right. This is a tremendous undertaking, and there is a lot here. We believe that we're doing what we were instructed to do. If we had the opportunity to say, legislature, don't make us do this by July 1, but give us more time, that would be something that would be pleasant, but we don't have that. We have thought internally about ways that we could process this so that it's not overwhelming. For instance, we are thinking that it makes sense to truncate out consideration of this so that we don't, like on April 29th, consider 2, 3, 4, 5, 6, 7, 8, and 9 all in one fell swoop. So what we've been thinking is that at your first couple of days of hearings, we should focus on the 300 and the 500 series. That's the sort of process series, and that's the 500 series, which is your rules about how you engage with you. Those tend to go together. And so what we're thinking is that we would open this up as one rulemaking, but have our stakeholders, our staff, and you focus on those 300 and 500 first. So we'd have pre-hearing statements on only those issues, and you would consider those issues first. And then once you're done with that, then we would have everyone focus on 200, 400, and 600, I think, is sort of the next topic that we would truncate together, and then we would and then have pre-hearing statements on that, and then you consider it, and then we respond to it, and then we're saving sort of 900 series, which is the issues around environment, around the new air proposals, around cumulative impacts, that you would consider that sort of at the end. We didn't think that considering that issue early on, I think that once you get through 900, you're going to go, whew, okay, we got through that. And so that's one method, Commissioner Boygan, that we think would help facilitate getting this done during the time frame that we have. The devil will be in the details. It still is a, hugely large, big, enormous task. Another thought would be for this commission to say, it's too much. We want to push some of this to the professional commission. We could do that. The way 181 is written is that the professional commission is seated the earlier of getting these rules done, or July 1, 2020. So if we get to July 1, 2020, and we've not gotten all of these rules adopted, professional commission gets seated. They then are the entity that would move forward with consideration of the rules that did not get done. We've talked about that internally. I've not talked about that with stakeholders, so I'm probably getting kicked underneath from my staff. But, I think that's a valid talking point. And so today, if you want to talk about it, if you want to think about it and get back to us, the problem is that, everyone thinks that every one of these topics is the most important topic. And so trying to figure out which one you would not address is probably going to be a difficult discussion, as well. But I didn't plan on going here with this today, but since you raise it, the mechanism of doing, rules by series is going to be helpful. The mechanism of knowing that we might need to have some hearings in early June to give you more bandwidth is another way of addressing that topic. The mechanism of not tackling everything and tackling the most important stuff and trying to figure out what's most important and then allowing the professional commission to take over, that's in the cards. So that's the best way I can try to answer a very valid concern that you raise.
Commissioner Boygan, follow up.
Quickly follow up, and I appreciate that. And I wasn't really asking for a definitive answer. I just wanted to get the issue on the table. But a couple of comments. One is, just looking over our experience the last few months, we spent a couple of days on the 500 series in what we thought was going to be a pretty straightforward, non-controversial set of procedural changes. We spent a couple of days on flow lines after the stakeholder process had pretty much gotten through a collaborative draft that was pretty close. And as I went through listened to your presentation, I could see any number of topics that in and of themselves could take days to address, even if you had stakeholders coming together. So I'm trying to be a little realistic here. And I'm wondering whether one way to try to slice it is to see which areas you can get a lot of sort of stakeholder consensus around, and get those done sooner rather than later. I don't know if that's feasible, and I, again, recognize the problem in trying to segregate out different parts that are related to other parts. And it may well be because of the process that you've started and are undergoing now, we will get through all of it, and it will be manageable, and that'll be great. I'm just not optimistic, I guess. But I'm, by nature, not optimistic.
Commissioner Hopkins and Commissioner Hahn.
Commissioner Boygan and Director. When I first got exposed to this concept, I was skeptical as well about it, and I urged the Director to think it through and be a little more realistic about what could be accomplished and prioritized, whatever. now that I look at what the staff has accomplished in a relatively short period of time and actually providing the straw dogs with all the language, which is really the nuts and bolts of what the rules are going to be, I changed my mind. I'm fully supportive of the director and the captain, if you will, of the voyage taking us down that path. Because one thing I've learned is that these folks know what they're doing and know how to do it well and are doing a great job with the stakeholders. Pre-formal hearing processes to develop consensus, and I know they have the ability to build upon that as we go. So I'm going to be an optimist. Normally I'm kind of try to be a realist, but I'm going to be an optimist at this point, and we'll just see how it goes. But I do have a request after saying these nice things about you and your staff, which I firmly believe. I would appreciate on the scheduling that you did and the dates, if you would just put out in a nice written style what series would be considered when, so that we could structure our activities more effectively so that we can be ready for each one and know when we're going to do it, how to do it, so we can at least in my mind, prioritize what I'm going to be doing in individual times to get ready for that first week of May, second week of May, third week of May, whatever. And I know you can change the schedule.
Yeah.
It's just it'd be helpful to have that benchmark to start
Well,
with.
and we wanted to have this discussion with the commission to see if the idea of approaching this, these two series first and then these series, if that resonated with you as a way to make this a more doable task. But we can certainly put our heads together and come up with the appropriate schedule. The other pieces to the schedule is right now we just have the hearing dates, and we need to back into that the publication of the rules, and then back into that the briefing structures that we would receive from parties, the pre-hearing submittals, et cetera. So we'll work on that over the course of the next period of time, and definitely not keep it so that it's like unknown.
Commissioner Hahn, then Commissioner Overturf, and then Commissioner Eaton.
Thank you, Commissioner Gibbs. So I agree with Commissioner Hopkins that we just go forward as though we're going to accomplish this goal and assume that it will happen in the time frame we've been given. I wonder if we could be given a summary of stakeholder opinions enough time ahead of our hearings that we can digest their thoughts, and so we can be more efficient with our time. I think if we have that input ahead of time, if we have specific questions formulated already, we can just click through it a little more quickly. Also, I wonder, is it possible as we go through each series to keep the record open till we're done, so that if we feel we need to go back and make any changes, we have that option?
If I could respond, Commissioner Hahn, those are two good questions. Let me answer the second one first. We have been working with our attorney generals about creating a path where the record remains open. So like, let's say you were to take up 300 and 500 and you get to a consensus spot and you all are in agreement that that's a good place for that to be. And then you move to the 400 and there's something that happens in 400 that needs to necessarily mean there's a slight edit to 300. The concept is that we would be able to do that. And so we are contemplating keeping the record open so that we could revisit previously discussed rules if changes are needed. Your first question about getting a summary of stakeholder input, I'm going to answer that by suggesting to stakeholders that they should work together to consolidate themselves into groups so that we don't have, 25 environmental groups saying 25 different things. It would really be helpful, and this has generally happened, where folks that have a like mind get together and coalesce and provide one pre-hearing statement that addresses the concerns from that like-minded constituency. it's going to be difficult for my staff to summarize all of the pre-hearing statements that we get. We'll do our best, but if we could encourage, and folks generally do this at the Colorado Oil and Gas Conservation Commission, but encourage like-minded entities to coalesce so that we provide to you through their pre-hearing statements one set of ideas coming from this perspective and one set of ideas coming from this perspective, you have a much better ability to digest what you are being presented with. So we will work on that, but that's something that we can do.
Commissioner Overturf.
Thank you. I have a more like substantive thing, but I'm going to not talk about that right now because we're in the middle of this process conversation, and so I want to weigh in on the process. I agree with Commissioner Boygan that every time I look at this calendar, I just sort of like, I'm filled with a lot of dread. But this is what we're going to do, and we're going to try to do it. I think that realistically, if we're doing these things in chunks, we should recognize that the thing that's on the end is the thing that might fall off the table if we run out of time. And so taking that into consideration as we're scheduling things. As staff is developing the kind of process for how we're going to receive input from the parties, I wanted to just reflect a little bit on the experience that I've had in the last few rulemakings. In advance of the flow line rulemaking, I recommended that we invite parties to file sort of pre-filed written testimony. And I will say, I regret that I made that suggestion because so few people seemed to trust me when I said that I had read them. And we saw a lot of presentations of evidence that were incredibly duplicative of the written material that had been provided to us in advance of the hearing, which I, as a good, industrious student, had read all of. So I guess I wonder if we want to, just to sort of take that into account as we're thinking about this, that if we require pre-filed written testimony, which I'm certainly not opposed to, that perhaps we limit the hearing time to commissioner questions. Again, truly trusting us that we will read what you put before us and we will have an opportunity to ask you questions, but you don't need to say all the things that we've already read. That may be a way to condense the time that we spend locked in these rooms together. The other suggestion that I had just on sort of a human being level is that when you're drafting the deadlines, to just please be thoughtful about giving us time to actually read the things before it's going to come up for a hearing. So we've got so many hearing days that are kind of all jammed in together that if something is due on Monday and we have hearings on Tuesday, Wednesday, Thursday, we're not going to have time to both sleep and read that and sit in the hearing room. I know, I'm so demanding. So just to give us some time as you're looking at that schedule and setting the dates, a little bit of a buffer so that we can actually do what we're all committing to and reading what people will file.
Commissioner Eden.
Thank you. I was going to say the same thing that Commissioner Overturf said about the thing at the end might be the thing that drops off. And just from my perspective, having been on this commission, I think would hate to have the cumulative effects piece be the piece that drops off. And so would want to really think about how we schedule that and think about the process. And then I also reiterate what she said about getting us enough time in the schedule to actually read the materials because, it's one thing on a shorter agenda, but we're going to have a lot to go through. So giving us more time to deal with the materials would be super helpful. And then I also have a substantive issue to raise, but I don't want to get us off process yet.
Just on the process questions, we get it, and we do need to build in sufficient timeframes to allow for you to read what has been filed. One of the things that we've discovered here with my rulemaking team is over the last week or two, we've done so much stakeholder outreach that we've received so much information that we did not build in sufficient time for us to read the stakeholder input we're getting to inform potentially changing the rules. And so we're now scrambling to find additional daylight hours or nighttime hours to get together and go over the input that we've received. So we'll, if I had a magic wand and I could build more days, I would do it. Yeah. But we'll try to build in so that, you know, even if you're not taking up the 400 series for 3 weeks, maybe we build in that the stakeholders go ahead and provide your comment so that we've got that in advance so that you've got times to be able to read through this. And this is even more significant because we're having you show up for meetings every other week for 3 weeks in a row. So we'll do our darndest to address that concern.
Commissioner Messner.
Thank you, Mr. Chairman. And I actually think we're going to get through all of this. And I have absolute faith. I believe in us. I believe in the work that's been done. I believe in the stakeholder process. I do believe that the stakeholder process that's been occurring, you know, over the last few months has really created a foundation of understanding at least what we're going to be addressing. I do think we need to address it holistically. I think if we get too siloed in our approach, then we lose the concept of evolving the regulations to ensure that we're looking at this holistically and being able to address, you know, what ultimately is the mission of SB 19-181, which is the preservation of public health, safety, welfare, the environment, and wildlife resources. And so I have the utmost faith that we're going to be able to accomplish this. I think we have to have that in our mind, that we're going to be able to accomplish this. But I will second very strongly what Commissioner Overturf indicated, which is I do think in order to be able to do this efficiently is to ensure that we get pre-hearing statements and that we read those pre-hearing statements and that we emphasize that if stakeholders are going to stand up and reiterate their initial statements, then that is a waste of our time and is a waste of the process. And so I would encourage us to, you know, ask that we get, you know, statements in advance and that we read those statements because I do think that that makes for a more efficient process. I don't think that things need to get reiterated, you know, as we're moving forward here. So that's the gist of it.
Commissioner Boygan.
Thank you, Mr. Chair. Listening to this discussion, I agree with a lot of what's been said. And one thought I had, I actually agree with the holistic idea. And I also don't want to see important items sort of fall off the table because we can't get to them. So one way to potentially get at that is to try to address everything at sort of a higher level and maybe build concepts or approaches into the first round of rules that we address and leave for later rulemakings the filling in of some of the detail that's got risks and potential benefits, but I'm just suggesting that it is important that we get to everything. And it may be that we can avoid getting bogged down in some of the arguing over detail by focusing on some of the higher level issues and objectives. Maybe some rules will lend themselves to that and some won't. But I would just suggest that you have that to think about as one potential approach if it starts turning out that we're getting bogged down.
Great. Anything else? Yeah, Commissioner Hopkins?
Just, I had this slight idea as Commissioner Boygan was talking about prioritizing and looking at it. My experience so far, which has been limited to just a couple of rulemakings, is that usually 80-20 rule applies. Lots and lots of those things that are being proposed by staff in the draft. Normally I hear we support most of everything that we're seeing here, and then there's a couple of items, 2 or 3, that become a critical few. And I think it'd be very helpful. I guess I didn't ever turn this on. I think it'd be very helpful when you have a staff presentation at the very beginning, perhaps, and you have this now new wealth of stakeholder informal input, as well as we get it through the pre-hearing statements and such. If you could simply identify perhaps some of the critical few, where we're going to have a lot of harder decisions to make perhaps because of where the stakeholders are, et cetera, and not worry so much about the rest of them, because that's the way it seems to be working so far. So I would just make that as a process suggestion.
Great. Commissioner Overturf?
I did want to just follow up on the actual substance of the presentation that you gave.
Could I ask one more, since we're closing out on process, could I ask one process thought? Commissioner Overturf, you had the idea of perhaps requiring written testimony but not having presentations, or having small presentations without duplication, so that it really is questions from commissioners to each of the parties. Not to put you on the spot, and you don't have to weigh in right now, but I would like some further, do other folks have views about that? That would do a good job of sort of narrowing how we're using your time.
I think we've all reiterated that if we have the information ahead of time and we do the reading and we're ready to go, then it sounds like a very reasonable way to proceed. We have the information from the stakeholders. We can ask questions and go forward.
Okay. Thank you, Commissioner Hahn. I think that was a positive. I think that your and Commissioner Hopkins' mics get real close, because folks on YouTube can't hear you.
Sorry. Better?
Better, much better, yes. So just right on top of it.
Okay. Do I need to repeat anything I said?
No, I think you just said kind of a thumbs up to the idea of not having as much in the way of formal testimony, and just rely on the fact that you guys will do and will certify that you've read everything.
Yes.
Yeah.
Yes. If we can have it ahead of time, we can get the reading done.
Do we see other thumbs up on that?
Can I just,
Commissioner Boygan?
quick comment? I like the idea support the idea of having written testimony in advance. I thought that was a great aid. I agreed with Commissioner Overturf on that. I wouldn't want to see it entirely replace oral argument, because I find oral argument very helpful. It allows parties to communicate with us in a relatively straightforward way what may get lost in some of the density of all the written material, and it also allows them to focus on what they think is really important. But I would like to encourage the parties, I would like to encourage the consolidation of that kind of approach, so that we're not hearing 5 different parties generally get up and say the same thing. And so I do support the notion of having written, in fact requiring written pre-hearing testimony, and not making it elective, which is what I think Commissioner Overturf was getting at. But then not entirely shutting off some kind of presentation, but having it be consolidated.
Thank you.
Commissioner Eden?
And I just had a question about that. If there's expert testimony, would the witnesses still be there even? Yeah, so we would still have access to the witnesses and be able to ask questions,
Yep.
but they wouldn't necessarily make a presentation. I think that's very important.
Okay, thank you for that. Turning to the substance.
Commissioner Overturf?
Yes, I do want to just let my fellow commissioners know that, in case you were worried that I wasn't asking as many questions as I normally do, that I wrote a bunch of things, and I'm sure it's sitting on Julie Murphy's pile of stakeholder input to take into consideration. So I have submitted a lot of questions that way, and look forward to having further conversations with staff. One thing that I didn't include in that, but that I wanted to raise as just a potato to throw into the stew, if you like it, is the idea of requiring. My understanding, as somebody who spends a lot of time in electricity world, is that there is a real opportunity to electrify a lot of end uses that are currently being powered by diesel generators at drilling locations. And I think we know that the operation of generators, it not only requires a great deal of fuel, but it also contributes to a lot of the other things that we're talking about, including greenhouse gas emissions, dust, noise, and odors, in addition to other things. So I wonder if there isn't an opportunity to discuss this concept with stakeholders about, are there specific operations at drilling sites that we can require or strongly encourage be electrified in order to, I mean, it's kind of a, I don't think you even kill two birds with one stone. I think you can kill a whole bunch of birds with this stone, even though I'm not trying to kill birds. So I think this should be something that is, I don't know if it has already been some of the conversation amongst stakeholders, but wanted to throw it out there as a topic for your further discussions.
I like that potato.
Thank you. Put it in your stew.
Any other comments? Commissioner Eden.
I just wanted to say I appreciate you guys getting out the air quality provisions, and I haven't really looked at it. I think that having been reading through all these rules and looking at all the things that can come in on sundry notices and Form 4s and get director approval, that I'm going to want to understand more about that provision that you mentioned about the director's exception on gas gathering, but and just what that process looks like. But I really appreciate you guys pushing and getting that out, because I know it's a challenging area and one that's getting a lot of interest. And I haven't had time to actually read the whole thing, so thanks for the brief.
Great. Any other comments? If not, Commissioner Davenport, I believe we have executive session.
Thank you, Mr. Chair. This is Assistant Attorney General Kyle Davenport. Commissioners, we've got executive session on the agenda, and pursuant to open meetings law, the Commission is entitled to enter into executive session at this regular meeting for the purpose of discussing pending or imminent court action with Commission counsel pursuant to Colorado Revised Statute Section 246402(3)A Roman 2. The topic of executive session was identified on the agenda. It is in the case of Our Health, Our Future, Our Longmont, and Food and Water Watch v. State of Colorado, Colorado Oil and Gas Conservation Commission, and the City of Longmont, Boulder County District Court, 20 CV 030033, to receive legal advice and analysis on claims and defenses in that case. Mr. Chair, I invite you to encourage a motion to enter into executive session for the matter and purposes I just named.
Okay, do we have a motion to go to executive session? Commissioner Eaton?
So moved.
Is there a second? Commissioner Hopkins? Any discussion? Seeing none, all those in favor say aye. Aye. Any opposed say no. Okay, we will move into executive session, and just so folks know, this is the last agenda item that we have on for the schedule. We will come back after executive session to vote to actually adjourn for the day, but we will not have formal, I guess, business besides voting to come out of executive session. So feel free to leave if you'd like. Thanks.
Test? Okay. So, commissioners, we're returning from executive session. During the executive session, the commissioner received legal advice on the claims and defenses in the Our Health, Our Future, Our Longmont et al. V. City of Longmont et al. Case. No decisions were made and no votes were taken during this executive session. Mr. Chair, I invite you to encourage a motion to exit executive session.
Do I have a motion to exit executive session?
So moved.
Moved and seconded. All those in favor, say aye.
Aye.
All those opposed, same sign. Motion carries.
So, thank you, Mr. Chair. We're out of executive session. All we need now is a motion to adjourn.
I will entertain a motion to adjourn.
I move that we adjourn.
Second.